Hello, folks. This is Eric Sinrod from Duane Morris Law Firm, international law firm based in San Francisco. You can see the Golden Gate Bridge behind me. I'm joined by my colleague, Jonathan Armstrong at Cordery, as ever, with our regular weekly, well, sometimes weekly, sometimes once every couple of weeks, video podcast that we've been doing now for more than half a decade. I think we're approaching number 300. I don't have the precise number on top of my head right now. But Jonathan, you're there in the UK, and you're not artificial, but you're thinking about artificial intelligence. So what's on your mind?
Yeah, I am, Eric. And I think we're at a sort of crossroads, I think. I know when we've done our predictions for the year ahead, we frequently said that one of the things that we see as tensions are the tensions between AI and GDPR. And I think when we've talked about it before, we've said all of the transparency obligations that are in this thick tomb that is GDPR, and it has all sorts of things in about being transparent with people, telling them how their data is being processed. And if decisions are being made by machine, not by human and not by human review, then you have to be clear about that as well. And in most cases, the use of AI will require a data protection impact assessment because of the way in which you're analyzing data. So I think we've always talked about that as a theoretical risk on these podcasts. But I think now's the time that theoretical risk is becoming a probable risk. And we've seen a number of regulators across Europe get annoyed by AI, and particularly the way in which people seem to be using AI unintelligently. There's always this conflict, I think, between the promoters of AI saying, I don't know, it's like magic beans. It's a black box. We input loads of data and it always makes the right decision. And of course, AI really isn't like that. AI can learn decisions and make decisions, but oftentimes people are programming what they're calling the AI box just by their own logic. So it's, if you like, machine programming sometimes, not necessarily independent thought. And with that, of course, comes biases and prejudices. So we may recruit people like us. And if we teach the machine what a good candidate is, then surprise, surprise, the candidate tries to select people like us because it follows its instructions. And of course, there's a whole debate going on at the moment about sentient computers, and maybe we won't go down that path, but suffice to say, there's no real solid evidence of computers making independent decisions. They're just doing that on programmable logic, if you like, even if that's interrogating big data sets. And regulators, of course, are concerned about the use of AI, particularly if people are discriminated against by the use of AI. Amongst our client base, recruitment is the most common use, I think, that they're buying in AI solutions that are, as I say, being sold as magic beans to HR teams, but HR teams perhaps aren't being as forensic as they should in looking into those applications. And when they do ask service providers, they're told it's part of the magic box and we can't give our secrets away. But regulators are increasingly frustrated by that. We've just had a fine of £7.5 million for Clearview AI in the UK. That's a long-running investigation from the UK data protection regulator, tag teaming with the Australian data protection regulator. And effectively, it concerns an awful lot of images, almost certainly images on you and I and everyone watching, that have been scraped from social media and other platforms and are being used to match people. Now, Clearview AI and people like that originally thought of marketing applications. Clearview AI have pivoted their business model to law enforcement, and it enables law enforcement, for example, to take surveillance camera images or CCTV camera images and try and match them against individuals to say who was in a particular place at a particular time. The Italian regulators have also been frustrated with Clearview AI, and they have fined 20 million euros in March. And both regulators, and Australia as well, have also ordered the destruction of images that relate to nationals in their country. We've also had the Italian data protection regulator, the Garante, be concerned about food delivery applications and how their use of AI reinforces prejudices. So riders who would not turn up and deliver food on a Friday or a Saturday or a Sunday were effectively marked down by the algorithm and assigned fewer jobs or less profitable jobs. But of course, Friday, Saturday, and Sunday could be the religious observant days for different members of the rider community. So effectively, these apps were discriminating against riders for celebrating their Sabbath day. And we've also seen a quite odd case out of Hungary, where a bank has just been fined around about 700,000 sterling for using AI analysis of customer sentiment in its call center. So if you rang in with a complaint about the bank, the magic beans were meant to be able to work out how angry and how persistent you were from the tone of your voice and handle the call differently. So if you spoke meekly and not bothered, and if you could possibly get back to me, according to the magic beans, your call would be deprioritized. But if you shouted and sounded important and assertive and angry, then your call would be promoted up the line. Now, it's fair to say that many people say that applications like that are really just magic beans. There might be nothing in the analysis. They rely on things like pauses in speech as well as speech patterns. And from what I hear, the regulator wasn't persuaded that there was any science behind this at all. But we are seeing concerns. And then a final point to make is we're also seeing your favorite litigation as well. So as we've talked about it before, the importation of US-style class action litigation into Europe. We're seeing that in the UK. We're seeing that in the Netherlands as well, by groups forming to litigate perceived data protection, perceived privacy harms. And in this case, there is an action progressing around ride hailing this time. So ride hailing apps, similar to the food delivery cases, were drivers allocated less work or less attractive work because the computer said that they weren't as loyal as somebody else, and because, as they allege, those computers weren't subject to human review. So I think we are going to see much more litigation and much more regulatory activity with this tension between GDPR and AI in 2022.
Very good, Jonathan. Well, we normally think of artificial intelligence as AI. Now it's MB, magic beans. So, let me cover 4 points briefly having to do with MB, magic beans, and there will be a little bit of overlap at the end. So first, I want to talk about privacy. AI systems use vast amounts of data, and therefore, as more data is used, more questions can be raised. Who owns the data shared between AI developers or MB developers and users? Can the data be sold? Should this shared data be de-identified to protect privacy concerns? Is the intended use of data appropriately disclosed and compliant with all sorts of legislation? So I just threw out several questions there relating to privacy. Next, I want to talk about contracts. The inherent nature of AI/MB may require individuals or entities contracting for AI services to seek out specific contractual provisions. In the past, software would literally perform as it was promised, but machine learning is not static and is constantly evolving. So that presents some issues. And parties might consider contractual provisions which covenant that the technology will operate as intended, and that if unwanted outcomes result, then contractual remedies will follow. These additional provisions might include an emphasis on audit rights with respect to algorithms within AI contracts, appropriate service levels in the contract, a determination of the ownership of improvements created by AI, and indemnity provisions in the case of malfunctions. So that was a little short discourse on contracts. Next, and importantly, and this gets to, I guess, my favorite topic, as Jonathan says, torts. Machine learning constantly evolves, making more complex decisions based on data it operates on. And while most outcomes are anticipated, there is the distinct possibility of an unanticipated or adverse outcome given the absence of human supervision. And the automated and artificial nature of AI raises new considerations around the determination who should bear liability. In the case of AI, is it the programmer or the developer? Is it the user? Or is it the technology itself? What changes might we see to the standard of care or principles relating to negligent design? As the AI evolves and makes its own decisions, should it be considered an agent of the developer? And if so, is the developer vicariously liable for the decisions made by the AI that results in negligence? And then we have reasonable foreseeability as a central concept to the principle of negligence. The further that AI systems move away from classical algorithms and coding, then can they display behaviors that are just not only unforeseen by their creators, but are wholly unforeseeable. And when there is a lack of foreseeability, are we in a position where nobody can be liable for the result, which damages others? I think we would anticipate that courts would not allow that to be the case. And maybe we would enter into a realm of what is called strict liability. We have that principle here in the US. I don't know if you have it there.
We do, yeah.
Yeah, and basically there, all you have to prove is that the defendant, in this case, the act of the defendant results in injury to the plaintiff. So there's a lot to anticipate potentially there. And then finally, where we have some overlap is this idea of bias and discrimination. And you talked about that quite a bit, but this can be more prevalent as more companies and governments turn to AI systems in their decision-making processes. I mean, Jonathan, you might be aware, but a 2016 investigation by ProPublica revealed that a number of US cities and states used an algorithm to assist with making bail decisions that were twice as likely to falsely label Black prisoners as being at a high risk of reoffending than white prisoners. To mitigate against built-in biases and collect the data, and then in the decision-making process, a number of companies have developed bias detection algorithms. However, these solutions might not necessarily solve the problem, because if we're training machine learning systems to mimic decisions made in a biased society using data generated by that society, will reproduce the original biases.
Yeah, no, very comprehensive. And I think we're juggling with the same issues over here. You know, if you're looking at things like autonomous vehicles, then there's a lot of work going on to try and answer just those questions. You know, is it the owner of the vehicle? Is it the producer of the vehicle? Is it the insurer? You know, how are we going to regulate all of these things? And I suspect that there are many difficulties to come for future legislation. And as I've said, and as you've said, in areas like discrimination, already areas where the law and AI do collide.
Yeah. So how do we wrap this up? Magic beans, man.
Well, I suppose we just say this is a topic that we're likely to return to in future, don't we? I think we encourage people to pitch in if they've got thoughts on this. We'll post this on our LinkedIn channel, the TechLaw10 LinkedIn channel, or you can add comments to the bottom of YouTube if you're watching it on YouTube. If you're listening on audio, then thanks for listening as well. And I guess all that remains is for us to say our contact details will appear on the bottom of the screen. I'm jonathan.armstrong@corderycompliance.com.
I'm Eric Sinrod at ejsinrod@dwaynemorris.com.
And we'll thank you for watching, listening, and tune in next time.
Thank you. Cheers. Bye-bye.